At a critical juncture that could dramatically affect the 2024 race for the White House, the United States Supreme Court is poised to examine an unprecedented legal challenge this Wednesday. The main issue is that former President Donald Trump could be suspended from pursuing another term on charges related to the January 6, 2021 Capitol riot. The case, which stemmed from a lawsuit filed last fall by a group of 5 Colorado voters, is based on the 14th Amendment to the Constitution, which was enacted after the Civil War in 1868 and did not give former government officials failed to maintain a rare clause of the official position. The provision known as the Sedition Clause has become an unexpected milestone in determining the eligibility of a presidential candidate, a situation unprecedented in American history. The legal issues reached a critical juncture when the Colorado Supreme Court declared Trump unfit to run for president based on his actions surrounding the siege of the Capitol in a landmark decision in December last year, effectively barring him from the state Republican primary. The decision sent the case to the Supreme Court, where it is now established that Trump vs. Anderson, and set the stage for high-level legal wrangling of complex constitutional questions. Not only does the case put the Supreme Court on a political footing similar to its role in the 2000 Bush versus Supreme Court, not only in the Gore decision, but it also tests the limits of constitutional law, which determines its significance for Trump's political future and statewide electoral climate ante. The composition of the court, including 3 justices appointed by Trump, adds another layer of complexity to the story. Legal experts and political analysts are closely watching the case unfold, noting its uniqueness and potential consequences. In an interview with APN News, constitutional expert Gerard Maglioccia said, "How rare is it for such a constitutional challenge to come before the Supreme Court, especially in the context of a former president with an eye. Re-election to the presidency is unparalleled. In a landmark legal challenge that went all the way to the United States Supreme Court, the Washington-based group Citizens for Responsibility and Ethics has launched a lawsuit representing 4 Republicans and 2 Colorado independent voters, a combination of results that has significant implications for American democracy and the upcoming 2024 presidential race. The lawsuit, filed in September 2023, argues that former President Donald Trump is constitutionally barred from resuming the presidency for his alleged involvement in the events of January 6, 2021. Central to this legal battle is Section 3 of the 14th Amendment, which prohibits individuals previously sworn to serve the U.S. The Constitution was followed, but then rebelled against holding any national or state office. Trump's actions regarding the riots placed him in this equally constitutionally unqualified. Krista Kafer, a prominent Denver Post columnist and one of the Republican plaintiffs, pulled back on the allegations against Trump, saying, "If you decide to tone down your oath, force your supporters burn, make all kinds of accusations that put election workers on the spot. In harm's way, then you. Trigger an attack on the Capitol to stop the peaceful transfer of power. And if you do things like that, you don't get to run anymore." A key turning point in the case came when District Judge Sarah B. Schmidt, who was presiding over the 5-day trial in Denver, sentenced him to 10 years in prison. This is the first time a judge has made such a ruling on Trump's actions. But Wallace also concluded that Trump should stay on top of the Colorado primary election, interpreting Section 3 as irrelevant to the president's office. But the Colorado Supreme Court reversed this interpretation in a 4-3 decision, disqualifying Trump from running for president, a decision that reflects the complex legal and constitutional questions at play. The development of the story in the U.S. The Supreme Court underscores the urgency and importance of the issue, and Trump and plaintiffs and voters are pushing for a quick settlement. Norma Anderson, the lead plaintiff in the lawsuit and a notable figure in Colorado's legislative history, delivered a poignant call to defend democracy, reflecting on her emotional reaction to issues that occurred in Jan. 6, and emphasized the importance of the constitutional principles involved. As the Supreme Court prepares to weigh in, the outcome of this unprecedented case could not only set the legal framework for the president, but could also confirm if American democratic values can endure when they face the challenges of the parliamentary process. Trump's legal team is pressing the Supreme Court to address several important questions. Does the sedition clause apply to the former president? Has Trump rebelled? And can the matter be enforced without a specific law in the absence of the legislature? Furthermore, it is argued that the clause, even if valid, only bars a person from holding office, not from running for it or being elected. Trump's main defense centers on the definition of head of the United States, a term that supposedly excludes the presidency. They argue that the framers of the Constitution would not have covered all presidential exemptions by including lower-ranking officials. This argument extends to presidential oaths, which Trump's lawyers note distinguishes them from oaths described in Section 3 that promise to protect, defend, and defend the Constitution rather than shyster it will help the answer. On the other hand, the plaintiffs and their legal representatives contend that the presidential oath carries superior constitutional support, rejecting the Trump defense as a specifically intended exclusion. They emphasize that constitutional qualifications should not be compromised by parallel age requirements that disqualify celebrities who do not meet constitutional criteria. The Supreme Court's decision on this issue has profound implications, not only for Trump's political future, but also for broader democratic principles and the rule of law in America. As the story unfolds, it examines constitutional limits on presidential eligibility and the resilience of American democratic institutions in the wake of contentious post-2020 elections. A ruling in Trump's favor could confirm his position on primary ballots and general elections, potentially through legal interpretations by judges. Conversely, a Colorado Supreme Court ruling upholding Trump's disqualification would have profound ramifications, possibly reshaping the 2024 presidential race by disqualifying states. Law Minister Press Millen stressed the urgency of the decision, saying, "We need to make sure we've got the right people going into the general election. The outcome of the case is eagerly awaited, as it will not only affect Trump's political future, but also set a precedent for how the eligibility requirements of the Constitution are interpreted and applied." Eric Olson, who represented Colorado voters who challenged Trump's eligibility, argued forcefully for the Constitution, arguing that evidence that Trump's insurgency would undermine the rule of law. As the Supreme Court considers this complex case, the nation awaits a decision that will not only affect the 2024 election landscape, but also confirm the strength and resilience of American democracy and its founding laws. With this information, we have come to the give-up of our publication. If you did not follow us yet, please do so and like our video. See you until the next video. Stay curious.